Okay, let's proceed.
Thank you, Chair. Mr. Vagela, before the long adjournment, you were still taking the chair through Neotelha's response to the reportable irregularity letter which you had issued, and you were referring to paragraph 1.3 of Neotelha's response, which appears at page 91 of the bundle. Overleaf at page 92, paragraph 1.4, there is a discussion about a meeting with Mr. Singh. Please take the chair through paragraph 1.4.
Chair, paragraph 1.4 indicates that Mr. Joshi met with Mr. Singh on the 11th of December. The meeting left him concerned. In a contemporaneous report to his management team, he stated that Singh seemed distracted and also changed his tune from the phone conversation I had with him on Saturday, and I'm not sure why. I mentioned to him that if we cannot reach resolution when the LOI will expire, and then what? He said we will see over the next day or two and then figure out what needs to be done. It was a strange meeting, but without an outcome. A meeting agreeing to meet again, in short. Not sure what to make of it. At the same time, Joshi received a report from Abid Kadri, who has led the negotiating team, to the effect that Transnet was engaged in a parallel discussion with Dimension Data, which had been the third and unsuccessful bidder in the original MSA bid process.
And at the paragraph that follows, paragraph 1.6, details a discussion that Mr. Joshi had subsequent to his meeting with Mr. Singh. Please take the chair through that paragraph.
When Joshi returned to the office after the meeting with Singh, he discussed the position with Stephen Wiley, the CFO. He had formed the view that Neotelha required assistance in getting the negotiations back on track, and recollected that Homex had successfully introduced Neotelha to Transnet in regard to the transaction for provision of Cisco equipment at the beginning of 2014. He could not remember the name of the intermediary, and Wiley reminded him that it was Homex. He then called a meeting with Abid and Francois. According to his contemporaneous note to his management team, he reported that, "I've been rattling my brains on how to overcome this stalemate. We may think the issues are trivial, but Transnet may think they are big. We can make out how sensitive they are with Harry's last email on the December invoice. As we discussed, it could be deal fatigue or just inertia or both. Reality is we need some help to now broker an outcome. So I've separately spoken to Francois and Abid just now, have asked them to explore the route of the consultant we used who brokered the Cisco deal at Transnet, and see if he is willing to help and at what cost. We don't have a lot of time, so time is of the essence."
Yes, and one of the concerns or questions you had raised with Neotelha was whether other service providers were considered by Neotelha, and that is addressed in paragraph 2.1 of that letter, where Neotelha sets out their answer to that question.
Chair, in the letter they articulate that they were not aware of any other service provider that could be contacted, given the severe time constraint with the imminent expiry.
And one of the other issues that you had raised were the credentials and expertise which Homex possessed, and that is addressed at paragraph 3.1 on page 93 of that letter.
Chair, they indicate that management were aware of a successful engagement with Homex during the Cisco transaction. The fact that this opportunity was brought to Neotelha, and the obvious inference that Homex had a business relationship with Transnet, which rendered such a transaction possible, led to the conclusion that in the absence of alternatives and with the time constraint, Homex should be invited to indicate whether they were able to undertake the assignment.
Now, with reference to that paragraph 3.1, were you aware of the background of the interaction between Homex and Transnet in relation to the Cisco transaction?
Chair, at this stage of the inquiries, we were aware that the Cisco deal was a finder's fee arrangement, in that Homix brought the Cisco deal to Neotel, and that's how the transaction was explained to us. However, when we go through further to the worksman's investigation, we then come to understand that the Cisco transaction was actually awarded to Neotel prior to any involvement of Homix, and that Mr. van der Merwe actually interjected and put Homix into the picture and made it out to be a finder's fee. So in the company's reporting, PRECA reporting, the company alluded that Mr. van der Merwe had defrauded the company.
And did you pick this up during your audit process? And maybe let me clarify, did you pick up the payment to Homix in relation to the Cisco equipment deal in your audit process?
Chair, in the payment was one of the transactions. However, the first one we picked up was the MSA period. Through our inquiries, management made us aware of the Cisco transaction, which was still within the reporting period 1 April 2014 to 31 March 2015. So it was one of the payments that were subject to further investigation and inquiry, and it does flow through in our reporting irregularities in the further reporting, in the subsequent reporting.
Yes. One of the issues that you had also raised with Neotel's management or the board was what exactly Homix had done, undertaken and or implemented in carrying out its mandate in connection with the negotiation and or conclusion of the MSA. That response is set out at paragraph 4.1 of Neotel's letter. Please take the chair through the response in this regard.
Chair, the response from the company indicated that Francois was the only party who communicated directly with Homix at the time of their appointment. Management had characterized their understanding of the assignment for Homix as requiring them to engage relevant executives at the CPO offices and the CFO offices at Transnet, present the value proposition of Neotel RFP, assist with the resolution of unresolved issues with Transnet causing the impasse, resulting in the conclusion of the MSA and the asset sale operational agreements, respectively. The services are described in the consultancy agreement signed by Neotel and Homix. Describe the activities as Homix to analyze the requirements of both Neotel and Transnet SOC to find a workable solution to the impasse in negotiations between Neotel and Transnet SOC in regard to the master services agreement and the related asset sale.
Yes, now this letter goes on to say that at paragraph 5.1 that the written response from Homix dated the 12th of December 2014 is annexed. Did you receive this letter?
Yes, we did, Chair.
And in this letter are the objectives of this agreement between Homix and Neotel set out?
Chair, the letter is very simple in nature, and it really outlines the fees to be paid. Chair, if the document you're referring to is on page 96, that letter doesn't contain the specifics that one would require and talks to resolving an impasse and finding a workable solution, and then outlines the fees to be charged. So in our review of this documentation, there isn't sufficient detail around what activities they are actually doing.
And this letter is at page 96
Yes,
of the bundle, and it is dated the 12th of December 2014.
yes.
And in the opening paragraph of that letter, it speaks of today's engagement. Is that correct?
Yes, that's correct, Chair.
And the engagement rather is with Neotel pertaining to the MSA.
That's correct, Chair.
And it further says, as well as the related asset sale negotiation with Transnet.
Yes.
at the second sentence of that first paragraph states that the talks have reached an impasse and Neotel wishes to engage the services of Homix to analyze both entities' requirements to find a workable solution. Is that correct?
Yes, that's correct, Chair.
The letter then goes on to say the work is to be carried out on a pure risk basis and Homix shall not bill for any time and material nor any out-of-pocket expense. Is this correct?
That's correct, Chair.
It further goes on to say if successful, Neotel shall pay Homix and states they 1, for the asset sale, a full and final once-off fee of 25 million, payable 30 days after signature. Is that correct?
That's correct, Chair.
It goes secondly, for the master services agreement, a fee of 2% of the value of the contract, and it says there in brackets, currently at 1.8 billion. Is that correct?
Yes, Chair.
Thirdly, it says these fees are excluding VAT. Is that correct?
Yes, Chair.
The letter then goes on to say these fees are success fee commissions payable because of the assistance and expertise provided by Homix, enabling Neotel to close these 2 deals that are currently agreed to be lost business as confirmed by both Neotel and Transnet. Is that correct?
That's correct, Chair.
In conclusion, the letter says, please concur the above together with the success fee structure where the latter shall become binding on Neotel. Is this correct?
Yes, that's correct, Chair.
From a reading of this letter, do you have any understanding of the specific service that Homix would have provided to Neotel?
Chair, we don't have any understanding of what Neotel is providing. Specifically, we would want to know the assistance and expertise provided by Homix, and that's not clear from this letter.
And so the commerciality of this agreement is not clear to you?
Yes, Chair, it continues to remain unclear despite receiving this letter.
If you look at how Homix defines their role, namely that the success fee would be payable because of the assistance and expertise provided by Homix, enabling Neotel to close these 2 deals that are currently agreed to be lost business. Does that help you in any way to say whether, if that is true, that would or wouldn't be a facilitation fee, that success fee?
Chair, a facilitation fee would probably be a legal determination. However, the circumstances would indicate.
What do you mean it would have to be a legal determination?
Chair, because one would need to prove. It is in our engagement and through our engagement with lawyers and lenders, to get to a facilitation fee, one needs it to be proven. So for us to conclude,
yeah, but there is something that if you are told, you would be able to say that's a facilitation fee.
Chair,
And if you are told something else, you would be able to say that's not a facilitation fee.
Chair, I would put it differently. We had a payment without substance, whether we call it a success fee, a facilitation fee.
But you wanted at one of the meetings to find out, is this a facilitation fee? So that's why I keep on going back to it, and partly because so-called facilitation fees have acquired a certain meaning on the market. So I'm saying, if you asked, you could be told a certain answer, and that answer could enable you to say that's a facilitation fee or that's not a facilitation fee. So here, they purport, that is Homix, to say what they would give in order to be paid this so-called success fee. So I thought you might be able to say, well, with this paragraph of what they say they would be doing, yes, that would be a facilitation fee, or no, it would not because of ABCD.
Chair, I would look at all the facts in its totality, and if we look at this letter and where one cannot articulate what Homix did do, and if we look at the timeline of the impasse and in resolving the MSA, it would appear so.
Well, they say they provided assistance in order to make sure that Neotelha and Transnet reached an agreement. Now, assistance, I can imagine, would be talking to both parties and getting them to resume negotiations and being able then to reach agreement.
Agreed, Chair, but in that instance, you know, I guess both parties will be able to say that they met with X, Y, and Z from Homix. They assisted us with the following clauses. They did this. They had specifics.
But on their version, they say what they were going to do is give assistance and use their expertise to help the parties to reach agreement.
Sure.
Does that fall within a facilitation fee?
Chair, if they cannot articulate the activities that they perform, then I would say yes.
You may proceed.
Thank you, Chair. Mr. Vagela, at paragraph 62 of your statement, you deal with the letter addressed by Homix to Neotelha, and that details the work that they had allegedly done. But before we go to that paragraph, at the preceding paragraph, paragraph 60, you deal with Deloitte's response to Neotelha's letter of the 5th of June, 2015. What, in essence, was Deloitte's response to Neotelha?
Chair, our letter of the 9th of June indicated that we had no further clarity on the commerciality of the transactions. If I can draw the Chair's attention to page 100, Annexure CV 15.
What annexure?
Annexure CV 15 on page 100.
Page 100.
Yes, what document appears at page 100?
It is a letter from Deloitte dated 9th of June addressed to the chairman of Neotelha.
And what are you communicating to Neotelha in that letter?
We're communicating our response to the information they provided to our inquiries of the letter dated 17th April.
Yes. And can you just take the Chair through your conclusion in that letter, which starts with, as pointed out? You don't need to read it, you can just paraphrase what the conclusion was in that respect.
Chair, Council, can I just make the Chair aware to some elements in the first paragraph?
Yes, please go ahead.
I think just in the first paragraph it says, furthermore, the clear reluctance of Homix to disclose information around the presentations made and or who the relevant individuals at Transnet are whom they met with leaves us with more questions around whether there is in fact any commercial substance behind these transactions. The response further does not clarify why the prescribed officers at Neotelha did not question who Homix is, what Homix would do, and or did to convince Transnet to conclude the deals with Neotelha, and what the payments would be used for. We must question why these inquiries were not made at the time, despite the implications or risks to the company that might arise from such payments. It seems to us that persons in the authority at Neotelha ought reasonably to at least suspect that the payment may have been a facilitation payment and ought to have considered their obligation to report such suspicion to the authorities under the Prevention and Combating of Corrupt Activities Act, Section 34. Failure to do so may not only be an offence under the Act, but would in itself constitute a reportable irregularity in terms of the Auditing Profession Act. Given the lack of specific and detailed information, you have not convinced us that there should not at least be a suspicion in this regard. Your Messrs. Pham and Offner have offered us to meet with Worksmans as the next step. However, we are of the opinion that Neotel and the board have to address the matter as described above. We will then consider the evidence and the appropriateness of the board's actions in our consideration of the matter and perform procedures as considered necessary in the conclusion of the matter and our audit. As pointed out to you previously, the potential impact of payments to Homex is pervasive to the company's business. Based on your response and the lack of information, we are in no better position than we were before in relation to the commercial substance of the transactions. For this reason, we cannot issue an audit opinion that is any different to the one included in the audit committee documentation submitted to you. Where Worksmans then took us through their findings. No report was issued other than the two-page document included under Annexure CV16.
And that would appear at page 102, Chair.
We were advised that Neotel reported suspicions to the relevant authorities in terms of PRICA, and we were provided with the summary of this report. This report is on page 102.
You don't need to read that report, but you can paraphrase for the Chair what in essence were the findings of this report.
Chair, the report in its essence concludes that Mr. van der Merwe, the former General Manager Strategic Customers, committed fraud against Neotel, potentially exceeding the amount in excess of the statutory minimum. He had a relationship with Homex, and he misled the company, which resulted in these payments to Homex and prejudicing Neotel in its negotiations with Homex and the MSA. So if I draw the chair to the second page, paragraph 17, it summarizes the conduct of Mr. van der Merwe.
Yes, and then at paragraph 62, therein you deal with a letter addressed by Homex to Neotel. Is this correct?
Yes, it is, Chair.
Can I refer you to page 105, which appears under CV17? Is this the letter that was addressed by Homex to Neotel?
Yes, it is, Chair.
And what is the date of that letter?
The letter is the 2nd of July 2015.
Now, if you start at page 105 of this letter, at the outset, the letter refers to two letters dated June 25 of the year 2015 regarding the agreement between Homex and Neotel pertaining to the asset sale and MSA between Neotel and Transnet. Is that correct?
That's what the letter indicates, yes.
And it then goes on to discuss these two agreements in the paragraph that follows. Is that correct?
Yes, that's correct.
Can you paraphrase what is stated in that paragraph?
At the outset, we wish to advise you that both the asset sale and MSA were covered under a single agreement between Homex and Neotel, and we're responding to both your letters, which are identical in content through this letter.
The letter then goes on to respond to several queries that were raised by Neotel, and it states there that Mr. van der Merwe was the single point of contact in Neotel. Is that correct?
Yes.
And that they have routed all research-related findings and recommendations that led to the successful conclusion of both agreements through Mr. van der Merwe. Is that correct?
That is correct.
If we turn over to page 106 from the outset, on that page, Homix provides a timeline of what they did in relation to these contracts. Is that correct?
Yes, that's correct.
And it starts off with the 11th of December 2014. Is that correct?
Yes, that's correct.
The timeline provides that on the 11th of December 2014, Mr. van der Merwe met with the Homix representative, being Mr. Mandla, at JB's Corner to advise of the status quo at Transnet and requested consulting assistance with a fresh perspective to help Neotelha close the deal. Is that correct?
That's what the letter says, yes.
It says that thereafter, both agreed to meet the next morning, being Friday, the 12th of December 2014. Is that correct?
Yes, Chair, that's correct.
And this was dependent on Homix being able to assist. Is that correct?
Yes, that's correct.
The following item on the timeline is December 12th, 2014. Is that correct?
That's correct, Chair.
It states there that Mr. van der Merwe met with Mr. Mandla as agreed at approximately 7 o'clock in the morning.
That's correct, Chair.
And it says that Mandla informed van der Merwe that they might be able to assist and fee would be same as before, namely 10% of transaction value. Is that correct?
That is correct, Chair.
And Mr. van der Merwe then said that he would return later that morning to confirm if this was acceptable to Neotelha.
That's correct, Chair.
Still on December 12th, 2014, being a Friday, it states there that they both met again. This would be Mr. van der Merwe and Mandla, as I understand it. Is that correct?
That's correct.
And it says there that Mr. van der Merwe said that they could only agree to 2% on MSA and a fixed fee on the asset sale, both done on full risk to Homix. Is that correct?
That's correct.
And it said that, which meant that if the contract did not materialize, Neotelha would be under no obligation to pay. Is that correct?
That's correct.
And it further says that after due deliberation of the pros and cons, we took the decision to agree to these terms and instructed Mandla to accept on behalf of Homix. Is that correct?
That's correct.
Then just below that date of the 12th of December 2014, it's stated there, and this is directed to Neotelha, as I've earlier stated, I wish to inform you here that I made a judgment call based on the possibility of the deal materializing immediately when I heard about it, and put my team on the job from December 11th itself. Is that correct?
That's what the letter says.
And it
yes.
says here, please find below a chronological sequence of the actions undertaken by our team to assist Neotelha in securing the deal. December the 11th in the year 2014 would have been on a Thursday. It then goes...
Sorry, Chair. Just on accepting the instruction on behalf of Homix, that Mandla accepting on behalf of Homix is contrary to the person that signed the letter. Just to note.
Yes. When the letter goes on further with this timeline, it says December 11, 2014, which would be on a Thursday. It says there that Homix...
Hang on 1 second. Is there a technical problem? Oh, okay. Let's continue.
Thank you, Chair. Just under actions taken at what seems to be at a high level, it says there, on December 11th, 2014, which would be on a Thursday, Homix deputed senior consultants with a high level of telecom expertise to quickly deconstruct the deal with a view to understand both parties' view of the transaction. After the team reported back, it became evident to Homix that the conceptual understanding from the Transnet negotiation team, and it says in brackets senior managers, was not the same as the view given by Neotelha. Thus, Homix immediately realized that they could add value by finding a lever that could possibly help Neotelha to negotiate an agreed position. Is this correct?
That's what the letter says, yes.
Yes. And it then goes on to set out events of December 12, 2014, being the following day on a Friday. It says they're subsequent to receiving verbal confirmation from Francois van der Merwe, we immediately assigned our senior consultants who were on standby to work round the clock and conduct intensive research from various sources with a view to find the lever that would help Neotelha get back to the negotiating table with Transnet and bring all on the same page on the real issues. Fortunately, our team was successful in coming up with a tangible solution which pinpointed several key factors and a principal lever, and in brackets it says, as detailed below, that Fransjo van der Merwe could use. Further goes on to say, Fransjo van der Merwe subsequently used the material provided to interact with Transnet. We also advised Fransjo van der Merwe to adopt an urgent approach with Transnet, citing the grounds that Transnet executives were scheduled to go on leave, and if this matter was not urgently resolved, the extension provision would kick in and Transnet would immediately be liable for wasteful expenditure, which would be reported to Parliament. Is that correct? And
That is correct,
yes,
per the letter.
as per the letter, on page 107, the letter goes on to say, using this approach, Fransjo van der Merwe was able to convince the Transnet negotiation team and executives to agree on a course of action and minimum terms with deadlines no later than Monday the next week. This was HOMIC's first step to get both parties back to the negotiating table. Now, just at this juncture of the 12th of December 2014 on a Friday, do you have any understanding or comment on the work that HOMICS states to have undertaken as up until this date?
Chair, to us, this is a letter. It's a one-sided letter from HOMICS. We could not corroborate this with the individuals mentioned. I mean, for example, Mr. Francois van der Merwe did not articulate these elements that he did or allegedly did. So it's a one-sided recommendation on what happened. But if we had to validate this or seek evidence to prove these facts, we could not do it.
The letter then goes on to say,
And secondly, we received this letter in July, which is after the period where Neotelha has reported that Mr. van der Merwe has defrauded the company. So we would not take any reliance on what Mr. van der Merwe did.
yes, lastly in this timeline, still cited as December 12, 2014, which is on a Friday, it states there that HOMICS advised Fransjo van der Merwe to facilitate a meeting between Transnet CFO and the Neotelha CEO, which he did. The meeting took place and both stakeholders agreed that their respective teams would meet on December 13, 2014, and not leave until they addressed all issues outstanding. In this context, HOMICS strongly advised Fransjo van der Merwe to ensure that the Neotelha executive decision makers be present in the meeting to ensure immediate decisions could be taken. Finally, due to HOMICS interventions, both parties understood each other's positions, and now that the executives were on the same page, agreement was reached on the outstanding points of dissension. Do you understand what then happened on December 13, 2014, being a Saturday?
We understand that the teams are said to have met through the Worksman's investigation report, and the matters were resolved, and Neotelha had signed the contract on the 14th of December.
And according to this timeline, HOMIC's intervention was from the 11th of December 2014, which was on a Thursday, and according to this letter, by Saturday, December 13, 2014, they had performed some other duties as they set out, which they have stated to be the basis upon which an agreement was entered into with Neotelha and payment made to HOMICS.
Chair, we still remain unconvinced because no one could articulate what changed in the agreement. Which aspects of the MSA did they engage on? What were the fundamental issues? Who at HOMICS engaged with the Neotelha team and the Transnet team? We weren't offered the opportunity to, no information around who assisted them in the deal was forthcoming. So whilst a fact pattern is articulated to give evidence to some activity, we could not verify that against credible evidence.
And having gone through this timeline from the 11th of December 2014 to the 13th of December 2014, do you have any view on the commerciality of the agreement between Neotelha and Homix?
We currently do not have any view on the commerciality between Neotelha and Homix, and it remained unsupported until the finalization of the financial statements.
From paragraph 65 of your statement at page 17, you then set out what Deloitte did following receipt of this correspondence from Neotelha. Please take the chair through these events.
Chair, following receiving this information, in Deloitte's view, the information did not address our concerns around the commerciality of the fees paid to Homix. Therefore, post the investigation and our opportunity to make inquiries, we raised an RI in respect of so if I refer the chair to paragraph 64, where we say neither the CEO nor the CFO of Neotelha conducted any due diligence investigation into Homix prior to Homix being engaged, nor did they ask any questions about what actions Homix intended to take in order to resolve the impasse between Neotelha and Transnet. In Deloitte's view, this conduct was not in the best interest of Neotelha and caused the company to sustain a considerable financial loss. Chair, in this instance, we raised an RI on the 14th of July. As if the CEO and the CFO considered all this information that was made available to them subsequent to the inquiries, the dismissing of Francois, the clandestine relationships, they did not exercise due care, skill, or diligence in authorizing the consultancy arrangement. They did not make adequate, due or adequate inquiries with respect to the actual activity to be performed by the agent, having regard to the nature of the consultancy arrangement and the magnitude of the payments committed thereunder, or adequately interrogate and or question the fees payable for the required activity. The officers, having nevertheless proceeded to approve and implement the consultancy agreement without adequate information as to what exactly the agent would do pursuant thereto, must, in our view, have reconciled themselves with the improper conduct of the agent and the ramifications and consequences thereof. Chair, I think in this instance we considered that management could not be willfully blind in considering what Homix was about.
And the RI that you have referred to, issued on the 14th of July 2015, is that what appears at page 117 under CV 18?
Yes, that's correct, Chair.
What then happened after Deloitte issued this report?
After the issuance of the report, we were engaging with Neotelha at the time, and in respect of the opinion that Deloitte had on the March 2015 audit of Neotelha. Neotelha sought a means to move away from the disclaimer that Deloitte had indicated it would issue, based on what Deloitte considered to be the pervasive effect of issues created by the Homix transaction on Neotelha's financial statements.
And can we turn to page 121 of the bundle? Annex to CV 19. Is that the letter that Deloitte received from Neotelha?
Chair, that is a letter that Deloitte received from Neotelha.
And what is the date of that letter?
The letter is the 7th of August 2015.
And this letter, is it in response to the reportable irregularity reported by Deloitte?
They do acknowledge the letter, the reportable irregularity letter, and they go on to various actions that the company has been taking in the engagement between Deloitte and Neotelha. Chair, this letter is also issued subsequent to the suspension of the CEO and CFO on the 31 July 2015 after an article broke the press relating to the Homex transactions.
If you turn to page 122 of the bundle, the paragraph, the fourth paragraph from the top, speaks to the investigations that were conducted by Neotelha. Is that correct?
Yes.
And it also replies to the report that was issued by Deloitte relative to the dishonesty of officers of the board. Is that correct?
No, Chair. We have not issued a letter around dishonesty. It says that their investigation have not found dishonesty on the part of the officers.
Yes.
And the board is unable to conclude that there is appropriate evidence to support your conclusion of deliberate or reckless conduct on the part of the officers. That is in response to the RI where we said they didn't make sufficient inquiry, exercise due care skill in engaging with Homex.
And in the paragraph that follows, Neotelha makes comments on the board's recognition of non-compliance with internal procedures. Is that correct?
Yes, they do highlight sort of breakdown in internal controls and that improvements would need to be actioned in that regard.
The letter then goes on to the following page, page 123. And at the bottom of page 122 is the conclusion in Neotelha's letter. Can you just summarize the conclusion made by Neotelha in this letter?
Sorry, Chair, on what page are you referring to?
The bottom of page 122.
Yes, at the bottom of that letter, Chair, the board effectively had ratified the CEO's authority, but however, it did not endorse or it had limitations to its authority, but it did seek to ratify the Homex mandate. If I read, with limited exception of the ratification of authority as described in point 2, the confirmation and ratification will not detract from the board's continuing review of the circumstances surrounding the Homex engagement and matters ancillary thereto, including but not limited to any failure on the party of any party or person to comply with the applicable law and without any restriction in respect of any of the company's rights or remedies concerning the Homex engagement.
Yes. Can we then return to your statement at paragraph 67 on page 18 of the bundle? At paragraph 67, you introduce the Vodacom transaction. Is that correct?
Yes, Chair. At the time, during the 2015 audit, Neotelha was subject to an acquisition by Vodacom, and that deal process was in play.
And for what purpose do you introduce this transaction at this point?
At this point, it becomes relevant because in terms of the audit process, we required Neotelha to disclose the matter to a number of stakeholders. Those would have included Transnet, to actually formally disclose it and obtain a waiver, to the lenders, as well as to Vodacom in terms of the sale and purchase agreement.
Then at paragraph 68, all the way to paragraph 76, you introduce a topic you have entitled Waivers and Disclaimers. Is that correct?
Yes, that's correct, Chair.
And what is the nature of these waivers and disclaimers to which you refer?
So currently, based on the evidence that we had, our audit opinion on the Neotel financial statements was a disclaimer opinion. Neotel sought a means to move away from the disclaimer opinion and asked Deloitte what was required in order to move away from the disclaimer. So in order to move away from the disclaimer, we required a waiver from Transnet to withdraw of its right to withdraw the MSA, so that they will not cancel the contract, as that had a material impact on the financial statements. We also required, in terms of the long-term funding common terms agreement, which is a lending agreement with the banks, we required a waiver from the Neotel's lenders around the Homex transactions, as the engagement of agents may be a potential sanctionable practice, and it may breach the lending agreement. And as a result, we said we required a waiver from the lenders. And furthermore, we required a waiver from Vodacom, as there was a potential sale transaction and the matter needed to be disclosed in terms of the sale and purchase warranties.
Just so that we clarify, in respect of the MSA, between Neotel and Transnet, can you just clarify how the contractual matters or issues would arise in your audit process?
So currently, the contract was concluded between Transnet and MSA and Neotel, and that MSA gave rise to revenue that was recorded in the financial statements of Neotel. If the contract was cancelable and there was found to be any wrongdoing of Neotel, there then needed to be a refund of the revenue recognized. The cancelable contract had a significant impact on the future viability of the business, and it pervasively impacted, and there was a cash element that would have impacted the going concern. So these elements around the Transnet contract were quite significant, and the resolution of that was quite a critical matter to resolve in concluding the 2015 financial statements.
And at paragraph 69.2 of your statement on page 19, you then set out the discussion between the Neotel's Audit Committee and Deloitte. Can you take the chair through this, please?
Chair, we communicated to the Audit Committee that to move away from a disclaimer opinion, a waiver from Transnet was required. A waiver from Transnet of its right to withdraw from the MSA based on Neotel's breach of the MSA by using an agent. The waiver from Neotel's lenders around the Homex transaction, and a waiver from Vodacom in respect of the Homex transaction. The Neotel Audit Committee had advised us that the lenders had been briefed and they were managing a waiver process. The Audit Committee advised us that they were seeking a waiver from Transnet. However, it was unlikely that a waiver from Transnet would be received. And therefore, Neotel was seeking legal counsel, a legal counsel opinion on the validity of the contract as a result of the breach of the terms of agreement. Following the legal advice, Neotel was advised that the matter had been fully disclosed to Transnet. Neotel continued to trade with Transnet under the contract, and vice versa, and they had to wait 90 days from notification to Transnet for any action or termination from Transnet. If these three activities had happened, then the contract would, and there was no action from Transnet, the contract would remain valid. The matter required full disclosure in the accounts in the absence of a waiver which was complied with.
If I might just take you back to paragraph 69.2, where the audit committee is asking Deloitte for their view and how the disclaimer opinion could be resolved. And Deloitte's view is set out at paragraph 69.2.1 until 69.2.3, and you've given evidence on this opinion.
Yes.
Would this be an audit opinion or a legal opinion? Because you had earlier, sorry, let me just complete. Earlier you had said that you had engaged CDH attorneys to assist you in this audit.
The opinion we're talking to in paragraph 69.2 refers to an audit opinion. The opinion referred to in paragraph 71 refers to a legal opinion around the rights of Transnet and Neotelha.
Yes. From paragraph 72 on the page that follows, page 20, you then speak to the waiver relative to Vodacom. Please take the chair through this.
Chair, at the time we requested a waiver from Vodacom. However, we were in discussion as to the impact of not receiving a waiver from Vodacom, and so the audit committee asked us to consider what would that do to our opinion. And so it was an open item. The matter effectively went away because the Vodacom transaction was abandoned, and therefore there was no further need for a waiver.
And can you just confirm who Neotelha's lenders were from whom waivers would have been required?
Chair, I don't have the list of all the lenders. The lenders' agents were represented by Nedbank and Investec.
Yes, and you deal with that at paragraph 76. Were these waivers eventually received from Nedbank by Neotelha?
Yes, Chair, they were received. The initial waiver was received on the 14th of December 2015. It's included in PAC CV20 and extra CV20.
And what, in essence, does the waiver contain?
So,
The
Chair,
first waiver of 14 December 2015.
Chair, if I draw your attention to CV 128 and CV 129, the waiver letter has a response to various clauses that are in the lender's agreement. And effectively what we're asking is, based on the knowledge around the HOMEX transactions, either the lender waives their rights around that there is a sanctionable practice, early termination of the Transnet MSA, breach of representations under the Transnet MSA, invalidity of the MSA, illegality or invalidity of the MSA, compliance with laws, compliance with the Transnet MSA, termination of the Transnet MSA. All these matters were requested in the waiver. Some of these were granted, and some of these were, the lenders believed that there was no breach yet that needed to be waived.
And can you be specific as to, still on the first waiver by Nedbank, which aspects did they say did not amount to any breach?
Chair, if I can draw your attention to page 722 of my statement,
Page 22.
or let us go to page 21 and I can read what's actually disclosed in the financial statements. At the bottom of page 21, we say the lenders have acceded to certain waiver of certain rights which the lenders may have now or in the future under the LFCTA in connection with the payments to HOMEX. The waivers were requested because the present facts, together with the facts as may possibly emerge in future, could indicate a breach of certain warranties by the company under the LFCTA, and also have an impact on the enforceability and or possible rescission of the Transnet MSA. which in turn may trigger certain rights of the lenders under the LSCTA. The company requested the lenders to waive their rights under clauses 1.190A, 1.190A3, 1.190A5, 30.16.5, 30.18, 35.4, and 36.63 of the LFCTA. The lenders have indicated that they do not think it is appropriate to grant waivers for the potential breaches of these clauses of the LFCTA, as it appears to them, based on the information provided, that no default has occurred and or is continuing in respect of these clauses. Thus, it remains within the lender's rights under the LFCTA to call an event of default should further adverse information come to the fore in relation to these matters, in addition to those that existed as at the date of approving these accounts.
And just for completion's sake, at page 128 through to 130 of the Nedbank's waiver letter, the matters that you have just spoken to, which the lender did not find to constitute a breach, the first would be at 9.1, is that correct?
Yes.
And it is stated there it relates to sanctionable practices.
Yes.
The second would be early termination of the Transnet MSA.
Yes.
The third would be breach of representations under the Transnet MSA.
Yes.
The fourth would be the invalidity of the MSA.
Yes.
The fifth would be the illegality or invalidity of the MSA.
Yes, that's correct.
The sixth would be compliance with laws. And the seventh would be compliance with the Transnet MSA.
Yes, and the eighth is...
And the eighth would be termination of the Transnet MSA.
That is correct.
You have made reference to 2 letters of waivers that Nedbank issued. The second one
The second one was...
appears at, under Annex to 21, as you've earlier stated.
That's correct.
And why was there a second letter of waiver issued?
Due to the timing of the matter rolling, we requested an update letter in June 2016
Yes. And this letter appears from page 132.
to 135.
Yes. Was there any significant difference between this letter and that which was issued earlier by Nedbank, pardon me?
No, they just continue to say that there's been no breach of the 2 clauses, and that we do not think it's appropriate to provide the waivers requested in paragraph 9.2. So it's on page 134.
Yes. And is there anything of material significance in respect of the waiver letters that you wish to bring to the Chair's attention?
There's no other fact other than that the lenders were aware of the matter, and until the matter was proven, the view was that there was no breach, and therefore we took the lenders the waiver plus disclosure in the accounts would inform a user on the matter.
Yes. Then from paragraph 77 of your statement, at page 22, you deal with the events that unfolded following the receipt of the waiver letters from the lenders. Please take the Chair through these events.
Chair, following the receipt of the lender's waiver and the disclosure of the validity of the Transnet MSA as outlined in paragraph 77, we were busy with the closure of the accounts being finalized in December 2017. Deloitte had requested that each of the Neotelha directors sign a management representation letter in their individual capacity. Chair, it's important to note that ordinarily we would request a management representation letter from the CEO and the CFO. However, given the circumstances and the nature of the matter that we were dealing with, we extended that representation to each of the directors to provide that representation to us. And the reason we did that is because we didn't know if some directors knew and some directors didn't, and if there was full disclosure of information from the directors. So each directors were requested individually to provide a a management representation letter. The letter was provided to the board on the 11th of November 2015 for the directors to review. A meeting was called by Mr. Memani on the 23rd of December to discuss this representation letter. In attendance at that meeting were Memani and myself at the Neotelha offices, and Mr. Pham, Mr. Reynolds, Mr. Teko, Mr. Bucks, and Mr. Dennis by conference call. We also at the time discussed the Vodacom transaction as well as the representation letter. A line-by-line review of the representation letter took place during the meeting. Amendments to the letter were agreed upon, except for the disclosure of information. Mr. Reynolds indicated that the directors were unable to sign the letter as there was apparently privileged information which they were unable to share with Dennis and I. I indicated in the response that if the information related to Neotelha, the company, then we as auditors would require sight of the information. Failing that, Dennis and I would need to consider the impact of this on our audit opinion. The matter was left on that basis, and that Deloitte would consult on this matter.
Now, at paragraph 80, you speak about the discussion that took place relevant to Vodacom. Is that correct?
Yes, Chair.
And you also speak of another meeting that took place on the 15th of January 2016. Is that correct?
Yes, that's correct, Chair.
And as you've testified, it related to the Vodacom transaction.
That's correct, Chair. At that meeting, we were debating some accounting issues around the Vodacom transaction, and at the same time, we raised the privilege information with Mr. Memani. And in that instance, Mr. Memani instructed Mr. Michael Hart from Norton Rose Fulbright to make the information available to Deloitte for the purposes of the audit. The privileged information that was made available included files and reports arising out of the worksman's investigation that was not previously provided to Deloitte.
And this information that was provided to you, you've set out at paragraphs 83.1 to 83.7 of your statement. Is that correct?
That is correct.
Now, given where in the stage of the audit process you were as Deloitte, did you find this information to be useful?
Chair, yes, the information was useful to us in that one, it was withheld. However, the information was concluded around 31 July, and the information, on reviewing that information, it further confirmed the suspicions that we had around the HOMIX fees paid.
And did you act upon your suspicions?
We did, Chair. On reviewing the information, we then reported a further 5 additional reportable irregularities, which are outlined in annexures C22 to C26.
And what was the date on which these 5 further reports were issued?
These reports were issued on the 8th of February 2016.
If we turn to page 138 of the bundle, would that be one of the reports that were subsequently issued by Deloitte?
That is correct, Chair.
And what is the basis on which this report was issued?
Chair, so in this report we articulate the success fees of 61 million rand, as well as the HOMIX fee of 30.3 million rand relating to the Cisco agreement. So that is 91.3 million rand, of which the commerciality and business lawful purpose remained unclear. We then indicate that the chairman of the company mandated Worksman's attorneys to conduct an independent investigation into the facts and circumstances relating to the transactions with HOMIX. From our inspection, which was completed on the 5th of February 2016, of the second preliminary report from Worksmans, dated 30 July 2015, and other supporting information and specialist reports obtained by Worksman's attorneys, we concluded that the directors and/or prescribed officers, after themselves having considered the report and such information, ought reasonably to have known or suspected that the payments to Homex had no business or lawful purpose, as referred to in Section 29 of the Financial Intelligence Center Act, and that the directors had failed to report this fact to the Financial Intelligence Center within 15 business days, as required in terms of Section 29 of FICA. So our duty was to report that the directors had failed to report their suspicion.
Yes, and if we can then turn to Annexure CV 24,
2023.
23, thank you, pardon me. That appears from page 141 of that bundle.
Chair, this RI relates to the same fees in question.
When you say the same fees, are you
the-
referring to the consultancy arrangement being the success fee of 61 million and the second payment of 30.3 million in relation of the Cisco fee arrangement?
That is correct, Chair.
So what is the difference between this report and the second report that Deloitte issued?
So this RI relates to a breach of another act. So we would report each RI in its own instance. And this one we concluded that the directors and/or prescribed officers, after themselves having considered the report and such information, ought reasonably to have known or suspected that the offence of corruption, as defined in Part 1, Section 3 of the Prevention and Combating of Corrupt Activities, was committed, and failed to report this offence to any police official in terms of Section 34 of PRECA.
So, as I understand it, the first report related to a breach in terms of FICA, and the second report related to a breach in terms of PRECA.
That is correct, Chair.
Can we then turn to page 145 of the bundle, please?
Chair, this report relates to further transactions that we introduce. In this letter, we introduced the company entered into back-to-back transactions, albeit with margin, with a customer, in this instance Transnet, and a supplier regarding CCTV transactions. A success fee of 45 million rand relating to the CCTV transactions was made by Homex to the supplier of Neotelha. The commerciality and business lawful purpose of the fees to Homex in other transactions relating to the same customer brings into question the CCTV transactions and the related success fees proposed and or paid.
Yes, and it goes on further to speak about the relevant legislative prescripts, which you say Neotelha acted in breach of. Please carry on at the following paragraph.
Chair, yes, so we then continue that we concluded
I'm
that...
sorry. That sentence, a success fee arrangement of 45 million rand relating to CCTV transactions was made by Homex to the supplier of Neotelha. Which supplier of Neotelha was that?
The supplier in question was TechPro.
Was?
Was TechPro.
Okay, thank you.
Thank you, Chair. Please proceed with the paragraph that follows.
So we, in this instance, we concluded that the directors and or prescribed officers ought to have reasonably known or suspected that the offence of corruption was committed and failed to report this offence to any police official in terms of Section 34 of PRECA.
Yes. Can we then turn to page 149 of the bundle?
Yes, Chair. This RI relates to the same 45 million rand referred to previously around the CCTV transactions, and we concluded that the directors ought reasonably to have known or suspected that the transactions entered into between the company and the customer may have arisen due to a fee proposed or paid by the supplier to Homex, and that no business or lawful purpose as referred to in Section 29 of the Financial Intelligence Center Act, and failed to report this fact to the Financial Intelligence Center within the 15 business day period.
Yes, so again, the two reports that you have just referred to differ only insofar as the violation of the applicable legislation, the first being in terms of PRECA and the second being in terms of FICA.
Yes, and the violation is in the director's or prescribed officer's failure to report.
Yes. Can we then turn to page 152, please?
Chair, the reportable irregularity under page 152 results in the financial statements for the year ended 31 March 2015, which had not been prepared and approved within 6 months of the financial year as required in terms of the Companies Act.
Yes. And can you just confirm the dates on which all these reports were issued?
All the RIs, there were 5 RIs, were all issued on the 8th of February 2016.
And were these RIs brought to the attention of Neotel?
We would have first issued the RIs to the URBA board, and then we would have issued it to the board of Neotel.
And was there any response received from Neotel?
We received a response.
Refer you, please, to paragraph 92 of your statement on page 27.
Yes, there were responses received on the 9th of March.
Of which year?
9th of March 2016.
And did you receive individual responses to each of the RIs, or did you receive a comprehensive response in relation to all the RIs that were issued?
There was the responses wasn't there was a response, but it was combined. So we received on CV 27.
That would be at page 155.
155.
Yes.
We received a response in respect of the CCTV transactions.
And if I can refer you to the third paragraph of that letter, starting with "it appears," can you please take the chair through that paragraph?
It appears to be a common cause following such discussion that there is no direct evidence in the worksman's report establishing agreement between Homex and TechPro for a success fee in the amount of 45 million rand or any other amount relating to the CCTV transaction. We refer to differences in profit margins between the two versions of the quotations directed by Neotel to Transnet in respect of the CCTV2 transactions in March-April 2015, as reflecting as a possible source of funds which might be used to make a payment to Homex. This information does not emanate from the 30 July Worksman's report, and there remains no evidence of any direct payment to Homex.
Yes, and can you then read the two paragraphs that follow after the paragraph you've just read?
Following our discussions which were conducted in terms of Section 45, 3A and B of the APA, you were advised that the company would, out of an abundance of caution, make a report in respect of the CCTV transaction based upon the suspicion of the offence of corruption under Section 34(1)A of PRECA, and a copy of such report will be provided under a separate cover. The absence of any evidence of an identifiable payment or of the parties making and receiving such payment or of an actual contract between such parties means that difficulties exist in populating a report to be made under Section 29 of FICA, particularly upon the basis of information set out in your letter dated 8th Feb addressed to URBA. Out of an abundance of caution, the company will report to FICA in terms of Section 29, and a copy of the report will be provided under separate cover.
Yes, please continue.
The company will instruct its legal advisors to consider and advise whether there is any recoverable loss arising out of the matter set out in this letter, and will take adequate steps to act in accordance with such advice. We therefore respectfully request your confirmation that you will advise that the suspected reportable irregularities relating to the CCTV transactions are no longer taking place.
Now, this letter from Neotel, it would appear that Neotel only addresses itself to the success fee of 45 million that was paid by Homix to TechPro. Is that correct?
Chair, we hadn't seen a payment, but we suspected that there was a payment arising out of the relationship between Homix and TechPro.
On what basis did you suspect?
Based on evidence where we saw in the Worksman's investigation that there was a letter that Francois had on-forwarded to, I stand to be corrected, but I think TechPro at the time. There was some evidence inferring an arrangement for Homix.
Yes.
And based on that information, we raised the suspicion around a fee payable on the CCTV transactions.
And that fee
The other concern for us was that every transaction with Transnet had a Homix element. You had the Cisco deal, you had the MSA, you had the asset sale, and we had two significant CCTV transactions that didn't have a Homix element. We just hadn't found it.
Yes. And in relation to Homix and TechPro, the success fee concerned there would be or was 45 million rand.
That is correct.
Now, in respect of the other reports that you had issues, did Neotel respond to those? Can I refer you to page 164, which appears as Annexure CV28?
They responded on the 7th of March,
Who is they?
Neotel,
Yes.
relating to the Cisco fee arrangement.
And what, in essence, is Neotel's response in relation to the Cisco fee arrangement?
Chair, can I just have some time to go through the letter?
Might I refer you to the third paragraph of that letter, which starts with the directors? Please take the chair through that paragraph and those that follow.
The directors were advised that the circumstances referred to in your letter relating to the consultancy arrangement and the Cisco fee arrangement were not reportable on a proper interpretation of Section 29 of FICA. Payments made to Homix arising from these transactions are devoid of any element of money laundering or transfer of proceeds of unlawful activities. The FICA's own guidance note records that Section 29 of FICA refers to reports being made in connection with the proceeds of unlawful activities and money laundering or terror financing offences, as opposed to criminal activity in general. FICA does not require reports to be made on suspected crimes or unlawful conduct by a person, apart from money laundering and terror financing activities. On receipt of your letter, the directors sought legal advice which confirmed the view set out above, but recommended that senior counsel be consulted in regard to this matter. After detailed consultation in regard to the interpretation of Section 29 1B2, senior counsel agreed that the section is ambiguous in its terms and may be interpreted in the manner set out above or on a literal basis, which would require a report such as you suggest, which would involve reporting in regard to every transaction involving unlawful activity or having no apparent business, regardless of the absence of any element of money laundering or the transfer of proceeds of unlawful activities. Having regard to this uncertainty, Council expressed a view that the company should file a Section 29 report in regard to these arrangements, indicating that the report is made out of an abundance of caution. The directors have accordingly resolved to file a report with FICA, which is required to be undertaken by electronic means, and you will be provided with confirmation of the filing of such report. The directors have acted prudently in seeking advice upon what you acknowledge to be a complex legal issue and have acted in accordance with such advice. They respectfully suggest that there is no basis for your assertion they have acted in breach of their fiduciary duties, and this view is consistent with the advice of external legal counsel and senior counsel. The company has already directed a demand for an accounting of the funds paid to Homex. We draw your attention to the fact that the success fee paid in respect of the consultancy arrangement amounts to 36 million and not 61 million. No payment was made in respect of the asset sale. No accounting or any payment has been received in response to the demand. The company has now formally instructed its attorneys to initiate proceedings for the recovery of the amounts dispersed by it.
Now, just on the last paragraph that you have read, where Neotel insists that the success fee relevant to the consultancy agreement was 36 million and not 61 million. What was Deloitte's view in that respect?
Well, it still is 61 million. It's just that they hadn't paid the 25 million.
The 25 million, which would add up to 61 million.
Yes.
And was there any other further response by Neotel to the reports that were issued by Deloitte?
There is a further letter on CV29, Annexure CV29.
And that would appear on page 167.
That's correct.
And what is Neotel's response to the one of the reports?
They also, in substance, they resolved to file such a report. However, they worked through the legal aspects of it. And I'll take the chair through it. Your letter records your conclusions following an inspection of a report received by this company from its attorneys dated 30 July 2015, together with supporting information and specialist reports obtained by the attorneys. Your inspection took place during the period 26 January to 5 February 2016. The inspection was for specific and limited purpose of enabling you to perform your audit of this company's financial statements, and you acknowledge that the disclosure and making available to you of the privileged, private, and confidential documents did not constitute a waiver of the legal professional privilege which inheres in the report. We confirm these terms for the record. The directors, upon legal advice, filed the existing report in regard to fraudulent conduct in relation to the consultancy arrangement and the Cisco fee arrangement in June 2015 under Section 34(1)(b) of the Prevention and Combating of Corrupt Activities Act. They were not advised to file any further report following the receipt of the supplementary report dated 30 July 2015, which confirmed that the matter had been so reported. On receipt of your letter under reply, they sought advice from the attorneys in regard to the matter. In view of the complexity of the legal issues, they were advised to consult senior counsel. The advice received was that an additional report should be made on the basis of reasonable suspicion in terms of Section 34(1)(a) of PRICA in relation to the offence of corruption as defined in Section 3 of that Act.
You needn't need the paragraphs that follow, but do you confirm that the last two paragraphs are the same as what was contained in the previous response relative to the directors resolving to file a report, and secondly, relative to the company having directed a demand for an accounting of the funds?
Yes, that is correct, Chair.
Can we then turn to Annexure CV30? On page 170. This is the second last response by Neotel to the reports made by Deloitte, is that correct?
Yes, that is correct, Chair.
And to which report is this letter addressing itself?
It's in response to the CCTV transactions in respect of PRICA and FICA.
Yes. Can you please take the chair through paragraph 2 of that letter?
In response to the management's discussions with you and the inquiry as to the evidence upon which you base your belief that the relevant officers ought reasonably to have known or suspected the offence of corruption, you advised that your belief was based upon the content of paragraph 25 of the first preliminary report from the attorneys dated 19 May 2015. The paragraph in question deals with the discovery, as part of the analysis of electronic communications of Francois van der Merwe, of a draft letter apparently prepared by van der Merwe, which appears to be an adaptation of the original letter dated 6 January 2014, alleged to have been addressed by Homex to Neotelha in relation to the Cisco transaction. The adaptation of the draft is to change the addressee to TechPro and to change the subject matter to the replacement of CCTV equipment, and the value of the project is estimated to be between 100 million and 200 million, excluding VAT. The fee amount is changed to 45 million rand. Minutes later, the same mail was sent by van der Merwe to another Homex-related email address with the invitation to please adjust and paste.
Yes. It then goes further to discuss Worksman's report.
There is, however, no evidence in the Worksman's report that the draft letter or any revision thereof was ever forwarded by Homex to TechPro, nor is there any basis for the conclusion reached by you in your letter that a success fee arrangement of 45 million rand related to the CCTV transaction was made by Homex to the supplier of Neotelha. The board of the company has no knowledge of any such arrangement, and inquiries made on its behalf with TechPro produced a denial of the existence of any such arrangement or the payment by TechPro of any amount by that company to Homex. The company itself has not paid any such amount to Homex or to TechPro.
Yes. Then the letter addresses itself to the commerciality aspect from page 171. At the second paragraph on that page speaks to the company having been advised in relation to the reporting obligation. Is that correct?
Yes.
Please take the chair through that aspect and the paragraph that follows.
The company has been advised and accepts that a reporting obligation based upon reasonable suspicion requires a critical analysis and assessment of the information and evidence upon which the suspicion is to be based. In the absence of any evidence that any letter was in fact addressed by Homex to TechPro, or that any agreement was entered into between Homex and TechPro, or that any payments passed between those entities, there is no reasonable basis for your proposition that the commerciality and business lawful purpose of fees to Homex in other transactions relating to the same customer brings into question the CCTV transactions and related success fees proposed and or paid. We respectfully suggest the absence of any evidence in the records of the company of any payment of a fee in respect of either of the CCTV transactions, the absence of any evidence that any contract was in fact entered into between Homex and TechPro, and the outright denial by TechPro of any knowledge of or payment to Homex reflect that your assumption does not meet the requirements of reasonable suspicion in a manner which justifies a report under section 34(1)(a) of PRICA.
Yes. Now, all these responses that Neotelha wrote to Deloitte in response to the reports,
Yes.
did Deloitte take the matter any further with Neotelha?
We did, Chair. However, the letter of 7th March, where they dispute the CCTV transactions, they subsequently agreed to on the 9th of March out of abundance of caution. And so we had suspicion around the transactions, and it was a matter to report them and to investigate them, not to negate a fact that we are raising, that there's this information. The onus on the company is to go and further investigate in a bit more detail, given the circumstances that are raised. And therefore, in our opinion, Neotelha had failed to report those transactions timeously by the 9th of March, and as a result, Deloitte had reported all RIs as continuing.
And what was the repercussion in that respect?
The repercussion is that the matter is disclosed in the financial statements as continuing, and then IRBA has the ability to act and inform the relevant authorities that they believe need to be informed based on the second RI.
Yes. Can we
Did
then?
you change your view on whether the matter was reportable?
Chair, we didn't change our view.
Yes.
We believed it was reportable,
Yes.
and the correspondence from the company does tend to agree with that view, because there were differing legal views in their correspondence, and so we didn't change our view. And the company actually did report it, but late, so it didn't help resolving the RI.
So didn't the company seek to persuade you to change your view on that?
They did, but they wrote to us on the 7th of March seeking to change our view.
Yes.
We remained firm in our view, and they sought legal advice again, and the legal advice concurred with our view, and therefore they decided to report out of abundant caution. However, they reported late. We received the reports late, and therefore the RIs remained continued.
Or I thought you were saying something to the effect that in regard to the CCTV matter, you changed your view or something.
No,
didn't.
we did, Chair. We didn't change our view.
Yeah.
There was the 7th of March correspondence was disputing that,
Yeah.
and then the 9th of March correspondence conceded with us, and therefore we remained firm.
You stood your ground on
we stood
all
our
the
ground.
matters.
Yes, on all RIs. Yeah.
Yeah. Okay.
Thank you, Chair. Can we then return to your statement at paragraph 94 on page 27? In that paragraph, you speak to events that took place during the period 9 March 2016 to the 30th of June 2016.
So during this period, we were busy with the 2016 audit, and a significant outstanding matter that was required was the funding of approximately 1.5 to 2.1 billion to conclude on the going concern of the company. In the absence of further funding from the shareholders or the lenders, this delayed the finalization of the financial statements for 2015 and 16. So the company required further funding in order to continue. At the same time, the company was subject to an acquisition by Liquid Telecoms. That acquisition was concluded on the 26th of June 2016.
Yes, and then at paragraph 96, you then speak to events that took place on the 15th of September 2016.
Yes, on the 15th of September, I received approval from the Audit Committee of Neotelha to engage with Kate Hennessy, the Group Financial Director of Liquid Telecommunication, in order to consider the impact of the sale transaction and the new shareholder funding on the going concern basis of conclusion. The resolution of the funding shortfall was considered through the sale transaction, and this would require the sale of the company to the new shareholders to be effective and all conditions precedents in the agreement to be met in order to sign the financial statements on a going concern basis. The sale of the company to Liquid Telecom was completed on the 10th of February 2017, with the conditions precedent to the sale and purchase agreement being complete, and on this date, the financial statements for the 2015 and 2016 were signed by the auditors.
Yes, and what was the status of the audit of the financial statements?
The audit was completed. However, the audited financials remain qualified in respect of the commerciality of the Homex transaction, and disclosure of this matter is noted in the financial statements as well as in the audit report.
Yes. Then you lastly deal with what transpired after the financial statements were deemed to be qualified by Deloitte.
Chair, at that stage, the audit is effectively complete. So on the 10th of February, we had concluded the 2015 and 2016 audits, but the commerciality of the fees paid to Homex remained unanswered and unsupported.
Yes, can I refer you back to page 155 of the bundle, which is annexed to CV 27. Earlier you referred the chair to a letter by Neotelha, which you state to have been dated the 9th of March 2016. Is that correct?
Yes,
Would that be the letter that appears at page 155?
yes.
And where in the letter does Neotelha appear to have changed its stance in comparison to its previous letter?
So following our discussions, which were conducted in terms of section 45, it's the fourth paragraph.
Yes.
Following our discussions, which were conducted in terms of section 45(3) A and B of the APA, you were advised that the company would, out of an abundance of caution, make a report in respect of the CCTV transaction based upon the suspicion of offence of corruption under section 34(1)A of PRECA, and a copy of such report will be provided under separate cover.
Yes, and you have taken the chair through this earlier.
Yeah.
You then conclude your statement in relation to the copy of the contracts that Homex entered into. Is that correct?
Sorry, Chair, if you just go further on to page 156,
Yes.
in the first paragraph, it also then says, at the end of that paragraph, out of an abundance of caution, the company will report to FICA in terms of section 29, and a copy of the report will be provided under separate cover.
Yes, thank you. And in the last paragraph, it stated there that the letter supplements the earlier letter of 7 March 2016. Is that correct?
Yes,
And further says that it replaces the conclusions set out therein. Is that correct?
yes, that's correct. Chair.
At paragraph 99 of your statement, you make reference to the contracts that Homex had entered into. Is that correct?
That is correct, Chair.
You make reference to Annex to CV 32 and 33. Is that correct?
That is correct, Chair.
If you go back to page 156, the second paragraph from the end of that letter from Neotelha, where it says, we therefore respectfully request your confirmation that you will advise the regulatory body that the suspected reportable irregularities relating to the CCTV transactions are no longer taking place. What does that mean?
It means the company was asking us that they were going to report the transactions, and therefore in our second report we should report them as the RI not continuing. The issue that we had was that we received they reported late, so they had provided the information past our deadline, and we had a deadline of the 9th of March, so we had got the information subsequent to us reporting it.
The irregularity that they were saying you must advise the regulatory body that it was no longer continuing was the failure to report.
That's correct, Chair.
So once they have reported, even though late, they were saying just confirm that there is no longer a continuing irregularity.
So, Chair, had they reported on the 8th of March, then we would have been able to accede to that. But they had it at the time of us providing our second report.
Yes.
We had not received evidence that they had reported.
Yes.
And therefore, we could not report that it was not continuing. We had to report that it is continuing.
Oh, okay.
Thank you. The copies of the Homex contracts you have attached as CV 32 and 33, and those annexures appear from page 175 of the bundle. Is that correct?
That is correct.
Is there anything in particular you wish to draw the chair's attention to in respect of those agreements?
Chair, the only aspect to draw here is that the agreements were separated to split the 36 million and the 25 million to be under the threshold of 40 million. The agreements were dated 19th Feb, when if we contracted in December, so it's after the event. And the person signing these contracts is not mentioned in any engagement with Homex.
And in the first agreement at page 178 of the bundle, paragraph 4 thereof sets out the consultancy services. Is that correct?
That is correct.
And it states there that the consultant agrees to undertake to analyze the requirements of both Neotelha and Transnet SOC to find a workable solution to the impasse in negotiations between Neotelha and Transnet SOC in regard to their master services agreement. Is that correct?
That's correct.
And with regard to the second agreement you have attached, if you go to page 190 at paragraph 4, from 4.1, well, paragraph 4 is entitled Consultancy Services, and 4.1 states there that the consultant undertakes to facilitate the successful conclusion of the asset sale referred to in the Master Services Agreement concluded between Neotelha and Transnet SOC Limited, in brackets Transnet. Is that correct?
That's correct, Chair.
It then goes on further at 4.2. It says, for the purposes of this agreement, A, customer means Transnet SOC Limited, and it says there, B, that project means the successful conclusion and signature of the asset sale forming part of the MSA concluded between Neotelha and Transnet SOC Limited.
That's correct.
And on the following page, page 191, C, it states there that Neotelha representative means Francois van der Merwe. Is that correct?
That's correct, Chair.
And if you go further down to paragraph 6 of that agreement on page 191, it states there at 6.1 that for satisfactory performance of the consultancy services, in accordance with the terms and conditions of the agreement, Neotelha shall pay to the consultant the fees as follows. 6.1.1, for the successful implementation and finalization of an operational agreement relating to the future maintenance, insurance, and operating of the assets bought by Transnet, and there's a correction from for to from, and it therefore reads, of the assets bought by Transnet from Neotelha, a full and final once-off fee of 25 million rands, payable 30 days after signature of the operational agreement between Neotelha and Transnet SOC Limited, currently anticipated for 18 March 2015, or any other later date agreed by the Neotelha and Transnet SOC Limited. Is that correct?
That's correct.
It then further goes on to say at 6.1.2 that the fees contemplated in 6.1 above are excluding VAT. Is that correct?
That is correct.
And if I might just revert back to the first agreement, which starts at page 177 under Annex J.
Chair, however, if what you've just read is in contradiction of the original Homex letter which talked about the asset sale.
Yes. Now, on page 180 of the first agreement, paragraph 6, which speaks to fees, states in 6.1 that for satisfactory performance of the consultancy services, in accordance with the terms and conditions of the agreement, Neotelha shall pay to the consultant the fees as follows, and it says there 6.1.1, for the successful conclusion and signature of the master services agreement, a fee of 2% of the value of the contract, and in brackets it says they're currently at 1.8 billion rands. At 6.1.2, it says that the fees contemplated in 6.1 above are excluding VAT.
That's correct.
Then at paragraph 7 of that agreement, it states their payment of fees.
Chair, it would be, if I refer you to 6.3, and that clause comes out of the Homex submission back to us.
Yes, which is the
That
letter
which-
that you took
which-
the chair through earlier.
Yes, which the chair, the wording is very similar.
Yes. And at paragraph 7, where it speaks of payment of fees, 7.1 states there that the consultant will invoice Neotel for consultancy services rendered on completion of the above set out in clause 6. 7.2 states, for the avoidance of doubt, all amounts due and payable under this agreement will be paid in respect of the master services agreement after signature of the master services agreement and after mobilization fee has been received by Neotel from Transnet SOC Limited. And lastly, at 7.3, it says that payment to the consultant of the fee shall constitute the entire and sole liability of Neotel for performance under this agreement. The consultant shall not be entitled to any additional fee or other compensation for any Neotel business facilitated through the services of the consultant unless expressly agreed in writing to the contrary. Neotel shall not be liable for any expenses or costs incurred incidental to performance of this agreement. Do you have any comment on the consultancy services as set out in the agreements and the fee arrangements that are also set out in these agreements?
The only comment I would have is that the 7.2 paragraph implies that a payment would have been received from Transnet first and then subsequently Neotel would make a payment.
And in respect of the other agreement?
I mean, the agreements were, this is part of our concern around these agreements, is that they are quite inconsistent to the fact pattern. So when you talk to the CEO, he talks about an asset sale. When you look at the letter, you have an asset sale. When you look at the agreement, you talk about an operational agreement. The CFO refers to that. So you have various inconsistencies in the agreement. This is also a Neotel agreement, whereas the supplier or the vendor is actually Homex. So it's not a Homex agreement to us. So there are various elements that do raise question around the agreements. But this was, I think, our view. You initially had the 12th of December letter, and then these were put together in February to address any risk.
Yes. And in respect of the commerciality of the Homex transactions, is there anything further you wish to bring to the Chair's attention?
Chair, I think as auditors we're required to be highly skeptical, and the more inconsistencies we get, the more evidence we require, and therefore when we look at the evidence, there was back and forth. However, the more questions we had, we did need more evidence, and that was never resolved, and that's resulted in the commerciality remaining qualified in the Neotel financial statements.
Thank you. Chair, we have no further questions for Mr. Vagela.
Thank you very much. You are excused. Do you know anything about tomorrow's arrangement? How many witnesses are scheduled for tomorrow? Is it one only?
Chair, as far as I know, it is only one witness who's coming tomorrow.
Okay, then we'll adjourn and start at 10 tomorrow.
Thank you, Chair.
We adjourn.